The committee will come to order. We have before us the Attorney General of the United States, and perhaps for the last time in the 110th session. His responsibility is that of enforcing our federal criminal laws, protecting voting rights, protecting us against foreign and domestic terrorism, for enforcing the antitrust laws, the bankruptcy laws, the intellectual property laws, and the immigration laws, as well as representing the government in civil cases. First, and perhaps most importantly, we've not seen enough cooperation concerning voting rights. The regular meetings on voting rights that I thought would happen between the Judiciary staff, bipartisan in nature, and the Department of Justice staff have not happened and have not been effective. As we sit here today, probably 100 days before the election, we don't know specifically how our government will respond to the practices that made the elections of 2000 and 2004 so problematical and so controversial. How we will respond to deceptive electioneering practices. Now, this is the highest order of responsibility between the Department of Justice and the Judiciary Committee, because we're going to be responsible, not just the outgoing Attorney General and the Department of Justice, but the House Judiciary Committee is going to be held accountable for what we did or didn't do in trying to make sure that many of the deceptive electioneering practices are stopped, and not just punished after the fact, but that we do something about it preemptively. How can we ensure voting machines are fairly allocated? How monitors will be deployed? How we'll respond to voter caging schemes and avoid some of the terrible mishaps of 2000 and 2004. In addition to the serious problems in those elections, we've seen numerous other voting problems. The approval of troubling redistricting plans in Texas and Georgia. This committee and everyone on it has responsibility for these 2008 elections. We have a hearing on voter rights and 2008 election tomorrow. And the Department of Justice, to this moment, doesn't have anybody committed to coming to that hearing. Chris Coates, the head of the voting section, hasn't agreed to come before us, and we're hoping that that can be remedied between now and tomorrow. Now, we've been trying to get key members of the Bush administration before us. They refused to. Harriet Miers and Josh Bolten have refused to cooperate in the contempt proceedings. And why? Because the Department of Justice publicly has said they're not going to enforce a subpoena against these two, the president's lawyer and the president's chief of staff. This Department of Justice continues to validate the unprecedented concept of total immunity for high-ranking officials, for example, KARL ROVE. Last week, they oddly argued that non-grand jury statements given to federal prosecutors were somehow privileged when it came to Congress. We've been waiting months and months to obtain critical documents relating to the selective prosecution, obstruction of justice, the secret OLC opinions advocating expansive theories of presidential power that strike at the very core of our constitutional freedoms. With less than 100 or so days remaining this delay, before the election and 6 months before the administration ends, this delay is unacceptable. And I'm sorry to say that the Attorney General has continued the unfortunate tradition of refusing to appoint a single special prosecutor for any of the evidences of misconduct that would require the Department of Justice to bring in outside counsel. Every member of this committee wants the Attorney General and this department to perform its mission fully. And it's more important now than ever before, with the world getting smaller, the global considerations, the military actions that still go on. And I hope that we are going to be able to conclude our relationship, Mr. Attorney General, in a way that we get some of these matters resolved and not that they were left hanging as we brought the 110th session to an end. We've got a big need for a lot of information, and I'm hoping that today will lay the groundwork for us to begin to accomplish as much of this as is possible. I now recognize the ranking member, Lamar Smith, for his comments.
Thank you, Mr. Chairman. Attorney General Mukasey, thank you for appearing before the committee for the second time, perhaps for the last time in this administration, to discuss the important work of the Department of Justice. We appreciate your doing so. Mr. Chairman, there are many important subjects the committee could focus on in its oversight efforts today. For example, we could make this a very productive hearing by having this committee take immediate action to address habeas corpus concerns following the Supreme Court's recent ruling of Boumediene versus Bush. On Monday, the Attorney General outlined the significant problems law enforcement officials now face as a result of that ruling. It is now the responsibility of this committee to act. In its decision, the Supreme Court opened a Pandora's box, and the Attorney General has made it clear that only Congress can close the lid by enacting clear rules regarding the detention of known terrorists. If this committee fails to act, federal courts may order the government to release known terrorists. There are more than 200 detainees remaining at Guantanamo Bay, and many of them wish to kill as many innocent Americans as possible. If this committee fails to act, sensitive intelligence on terrorists may be disclosed, and terrorists will know better how to evade detection and conceal future plots. And if this committee fails to act, known foreign terrorists will be able to forum shop for the most favorable places to bring their claims, both in the federal district courts and in the Court of Appeals for the D.C. Circuit, in a way even domestic American criminals cannot. The Attorney General has told us what common sense tells us. We must commit ourselves to the development of a legislative proposal that provides clear guidance on the detention of known terrorists. We must act responsibly, and we must act quickly. Another area where Congress can assist the Department is in protecting America's children from sexual predators and cyber criminals. Nameless, faceless criminals use the World Wide Web as their virtual hunting ground. Child exploitation, child pornography, and cyber bullying are just a few of the 21st century crimes threatening our children today. A simple step Congress can take to enhance our crime-fighting efforts is to require the retention of certain subscriber records by Internet providers. This committee must pursue this and other innovations if we have any hope of keeping pace with crime in the cyber age. One of the areas where there already is bipartisan agreement is in confronting and deterring criminal activity in the arena of intellectual property theft. We should help advance the legislative efforts of this committee, including the Prioritizing and Organization for Intellectual Property Act of 2008, which passed the House overwhelmingly in May, to enhance IP enforcement efforts. Also, I am pleased with the Department's recent work to support DHS's immigration enforcement efforts by increasing prosecutions and available prison bed space. For too many years, illegal immigrants knew that they faced absolutely no penalty if they were apprehended along the southern border other than a quick bus ride back across that border. They had every reason to try to enter again and again until they eventually succeeded, as 90% of them did. The Justice Department's Operation Streamline, for the first time, has put an end to this revolving door. We have too much at stake to shy away from enforcing the law and ensuring that individuals entering the U.S. do so legally. Mr. Attorney General, I appreciate the tireless dedication of the men and women of the Justice Department and look forward to working together with you to keeping Americans safer in the future. Yield back,
Mr. Chairman.
Thank you. Yes.
Would you yield to a colloquy, a brief colloquy?
Absolutely not. The Attorney General brings a long, distinguished background to the Department of Justice. He's been a practicing attorney, a federal prosecutor, a member of the firm of Patterson et al., a trial judge since 1988, and was appointed by President Reagan as a trial judge for 18 years. 6 of those were as chief judge of the district. He retired in 2006, was called back by President Bush, confirmed as the Attorney General in the fall of 2007. We have your statement, sir, and it'll be entirely put in the record in its entirety, and all the members will have an opportunity to add their own opening statements to welcome you here. Thank you so much.
Chairman Conyers, Ranking Member Smith, and members of the committee, I thank you for the opportunity to testify here today. Since I appeared before this committee almost 6 months ago, I've become even better acquainted with the talented and dedicated professionals at the Justice Department and with the work that they do, and have come to appreciate that much more deeply their service to our nation. I've now been Attorney General for slightly more than 8 months. During that time, there have been moments of disagreement with members of the committee, as there always will be. There are policy initiatives that the Department supports that some members vigorously oppose, and policy initiatives that some of you support that the Department opposes. There are also situations where the interests of the executive branch and of the legislature are in tension. This is not, as some people have suggested, evidence of a broken or a flawed political system. It's part of the genius of the design of our Constitution, which embodies a robust separation of powers. Although these tensions will never disappear, there are many areas of agreement in which we can work together on behalf of our common clients, the American people. I'd like to outline briefly 2 areas that I will focus on during the 6 months remaining in this administration. First, with the first post-2001 transition looming, we must take every step to ensure that custody and responsibility for our nation's security is transferred smoothly to a new set of caretakers. That means putting national security measures on a sound institutional footing so that the next Attorney General and the new administration will have in place what they need to continue to assure the nation's safety. 2 weeks ago, Congress took a vital step in passing the FISA Amendments Act of 2008, bipartisan legislation that will give our intelligence professionals critical long-term authorities to monitor foreign intelligence targets located overseas. Earlier this week, I called upon Congress to take another step by passing legislation to address the questions about detainees unresolved by the Supreme Court's recent decision in Boumediene versus Bush. Congress and the executive branch are in a far better position than the courts to create practical procedures and rules to govern the habeas hearings required by the Supreme Court. Procedures and rules that would both give the detainees what process they are due, and accommodate the grave national security concerns involved. In my speech earlier this week, I outlined 6 principles that should guide such legislation, and I look forward to working with you and your colleagues on both sides of the aisle and in both houses of Congress to address these important issues promptly. Second, as everyone knows, the election season is upon us. Although state and local governments have primary responsibility for administering elections, the Justice Department must make every effort to help assure that the elections run as smoothly as possible, and equally important, that the American people have confidence in the electoral process. The Department will maintain a significant presence throughout the election season through both outreach and monitoring. We will work closely with civil rights groups and state and local officials to identify and solve problems. We will publicize telephone numbers and websites through which people can bring potential issues to our attention. And on Election Day, we will deploy hundreds of observers and monitors around the country. These steps will supplement our ongoing efforts both to enforce laws, including the Voting Rights Act, designed to guarantee access of all Americans to the ballot, and to enforce laws, including those prohibiting voter fraud and campaign finance abuse, intended to safeguard the integrity of the voting process. All these efforts are essential in ensuring that elections reflect the will of the people and in maintaining the confidence of all Americans in our system of government. In all of this, we will be driven by what the law and the facts require, and only by that. In fact, I've said many times, both to members of the public and to Department employees, that we must pursue all of our cases in that manner. I have also said many times that we must hire our career people without regard for improper political considerations. And I have acted, and I will continue to act, to ensure that those words are translated into reality. I am well aware of the allegations that politics has played an inappropriate role at the Justice Department. Too many of those allegations were borne out in a recent report by the Department's Offices of the Inspector General and Professional Responsibility on hiring for the Honors Program and for the Summer Law Intern Program. Even before I became Attorney General last fall, however, the Justice Department had taken many significant steps to remedy the problems that existed. I have since taken several additional steps, and we will continue to take any and all steps that are warranted. It is absolutely crucial that the American people have complete confidence in the propriety of what we do, and I will work to make certain that they can have such confidence. Mr. Chairman and members of the committee, I thank you for the opportunity to make these remarks, and I look forward to answering your questions. Thank you very much.
Thank you. The Chair recognizes to begin the questioning the Chairman of the Subcommittee on the Constitution, Jerry Nadler of New York.
I'm sorry, Mr. Chairman, I don't mean to raise a matter that's none of my business, but I haven't been placed under oath. Did you want me to take an oath or simply?
No, I did not require
I'm
that.
sorry. Go ahead.
Jerry Nadler.
Well, thank you, Mr. Chairman. I have a number of questions, and I hope we can be brief. The first one is, when you last appeared before this committee, sir, you stated that you could not order an investigation into interrogation practices that had been authorized by OLC opinions because it would not be fair to infer any possibility of criminal intent to someone who was following an OLC legal opinion. But it's now clear that one of the detainees, Abu Zubaydah, for example, was interrogated for months in the spring and summer of 2002 before the first OLC opinion on the issue that we know of. The August 1st, 2002 legal memo by John Yoo was issued. And Attorney General Ashcroft testified last week that he did not recall providing legal advice on interrogation methods at that time and did not recall whether anyone else at the department had provided such advice. Now, given the uncertainty about whether any legal advice had been provided before these interrogations, have you or anyone in the department investigated the legality of the interrogation methods used before the August 1st Yoo memo was issued?
I have not investigated that myself. I think part of that question involves whether the methods employed were consistent with that memo or not, and I don't know whether they were or they were not.
Well, do you think someone should take a look at that?
I think a look at that may very well be taken or have been taken. I'm not specifically aware of it as I sit here.
Can you let us know?
I will take a look.
Thank you. Now, one other thing. The committee has issued a subpoena for all unclassified OLC opinions on issues of national security and presidential power that have not previously been released. The department has refused to provide these unclassified opinions to the Congress. Can you tell us why we can't get those unclassified opinions?
Without getting into any particular opinions, there are two considerations that relate to OLC opinions. One has to do with classification.
Oh,
as you point
unclassified.
out. Unclassified opinions. OLC opinions are there because somebody has come to the department for advice. They've come to the department for advice before they act. Part of maintaining a deliberative process is being able to assure them that they can come to the department, ask for advice, and get it without.
But that's in effect a claim of executive privilege. That is the executive privilege.
It's not really the executive privilege. It is a deliberative privilege, if you wish to call it that is different from.
So you're asserting a new privilege other than executive privilege?
I'm not asserting a new privilege. I'm explaining that deliberative process is part of what you may call executive privilege, what I think is actually something separate, but in any event is one of the kinds of information that's protected from inquiry on the outside, and for good reason.
But wait, whatever the good reason, I don't want to debate the reason, but if it's not protected against a subpoena by executive privilege, what is the legal authority for not giving it to Congress when subpoenaed?
I believe that we are authorized to keep in confidence requests for advice and the advice that we give as counsel, as part of a deliberative privilege, as part of essentially an attorney-client relationship, and for other good, sound reasons that I'm sure you can understand.
Well,
we want people to come for advice. We don't want them to act without.
I understand the reasoning. I do not agree, and I would ask you to provide to this committee the legal authority. I do not agree that there is any privilege other than executive privilege. The executive privilege must be claimed by the President. The President is not the client of the Attorney General. He's the client of his own counsel, but the government is the American people are the client of the Department of Justice. So I do not see any grounds for withholding the subpoenas. But let me go on. I just ask you to then provide the committee with a legal basis for this. I have another
with basis additional to the basis I've already articulated.
Well, but with some citations. We know that many states now, going back to the chairman's comments, are preparing purge lists of voters, lists of people who shouldn't be allowed to vote because, pursuant to the laws of the states, they're felons or whatever. We also know that in Florida, for example, in 2000, such a list was prepared by a commercial vendor. We know that there was a 20% error rate. We know that they knew there was a 20% error rate, which means they knew that 1 out of every 5 people prevented from voting would be legitimate. What is the department doing to oversee, to make sure that states cannot do that again, that the purge lists that are being prepared do not disenfranchise many legally eligible voters?
Very broadly and then very narrowly. The department has been working with state and local authorities to make sure that they conform with the requirements of all federal voting laws and that they conduct their activities in a responsible way. That said, there is always available, and we are making certain of this, the alternative for everyone who feels that he or she has been improperly denied the right to vote, challenged in trying to exercise the right to vote, to nonetheless cast a provisional ballot. And we're making certain that people are aware of that. We're doing outreach to civil rights groups to make certain that people are aware of that, because that is, as it were, a fail-safe against the kind of practice that you just described. I don't know whether it happened. I don't know what the source of that is. But assuming that it happened, that's the ultimate fail-safe. We have been in communication with state and local authorities, and we have an extensive training program for our own people to make sure that it doesn't happen again if, in fact, it happened.
Thank you. I see my time has expired. The chairman will admonish me shortly. So,
Lamar Smith.
I don't think he will.
Thank you, Mr. Chairman. Mr. Attorney General, I have a couple of questions about the Boumediene versus Bush Supreme Court case. When the Supreme Court issued its ruling, Judge Lamberth, the chief judge of the Federal District Court in D.C., took the unusual step of issuing a news release saying that he hoped Congress would respond and address some of the questions raised by that case sooner rather than later. My question is, do you feel that it is urgent that Congress act quickly to address some of the questions raised by that case?
I do feel that it's urgent. Actually, I think he issued that statement after the speech that I gave urging the legislation. Okay. I do feel that it's urgent. I outlined reasons in a 20 or 25-minute speech why it was urgent, and urged that essentially 6 principles inform any legislation. But I was not drafting legislation. What I was urging was that Congress step up and do it.
Right. What are some of the unintended consequences of that ruling? Why is there a sense of urgency, without getting into the principles, but just what are the risks involved if Congress doesn't?
Of course, the ultimate risk is because the ultimate decision finder has to be able to direct release. The ultimate risk is that one of these folks could be released in the United States, and that is something that we think has to be prevented. Secondly, there is a matter of national security. Much of the evidence against the people at Guantanamo, both those charged with war crimes and those whom we're simply holding because they are detainees, comes from classified information. We need to protect how that information is used, who has access to it, and who doesn't. Third, there are, as I said, some of them are going to be put on trial for war crimes, and we have to make sure that habeas proceedings are not used as a way of delaying the onset of military commission trials any more than a United States defendant charged with a crime has a right to file a habeas proceeding before his trial. No U.S. defendant has that right. We don't think these folks should be given that right. We think that Congress should reaffirm that we are in fact involved in an armed conflict and that there is a right to detain enemy detainees. There is a separate question of whether those people are guilty of war crimes or not. That's a whole separate thing. But detention is an absolute, and it's something that there has to be firm authority for. We think there is, but we think it wouldn't hurt to reaffirm that. Congress, I think, should establish sensible, streamlined procedures that strike a reasonable balance between a detainee's rights to information and to present a case, which the court said he had to have, as well as practicality. And the word practical appeared numerous times in the Supreme Court decision, but they stopped far short of articulating the exact procedures that should apply. And finally, we asked that Congress make sure that detainees could not pursue remedies other than habeas corpus. As it stands now, they have kind of a two-track system. They have what are called the CSERTs, the Combatant Status Review Tribunals, and review of those in the D.C. Circuit, and then they have the habeas petitions. We think, in view of the requirement of habeas, that the CSRT system and appeal to the D.C. Circuit should be cut off completely and simply rely on habeas proceedings that are properly cabined in the way that I've suggested. That's a rough outline.
Okay, good. Thank you, Mr. Attorney General. Let me go back to your first 2 points. The first was that some of these individuals might be released. As I understand it, there are some known terrorists that are now being held at Guantanamo Bay. And are you saying if we don't act expeditiously that some of those terrorists might be released?
There is always that possibility. I mean, we have, so far, obviously it hasn't happened, and so far I want to commend the D.C. District Court for the preliminary steps that it's taken, including having, by and large, one judge, although not entirely, there are 1 or 2 other judges who are going ahead, but one judge principally organizing things procedurally so that they proceed in an orderly way. But if somebody decides that they want to bring somebody here either to testify on his own or in somebody else's proceeding, there are additional rights that that person has simply by virtue of landing on American soil. And recall that these are all aliens. None of them has a right to be here. We don't want that to happen inadvertently and then have the outcome of a habeas petition be that somebody has to be released, and if he's on American soil, he gets released here. That, we think, would be the worst outcome, and we're trying to avoid that, and we think it can be avoided with legislation.
Okay. Thank you, Mr. Attorney General. Thank you, Chairman.
The Chairman of the Crime Committee, Bobby Scott.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being with us today. I had a couple of questions in the area of the criminal justice system. First, in reference to the housing crisis, it appears to me that with the billions of dollars that's been lost, somebody has made a lot of money to a large extent in my opinion, through criminal fraud. And we're going to try to get a briefing from the Justice Department on this in detail, but could you just say a quick word about whether or not, in your view, crimes were committed that helped perpetuate the crisis that we're in?
Without wishing to convict anybody before trial, we have so far charged more than 400 defendants in connection with the mortgage crisis that you mentioned, ranging up the scale from the people who are overvaluing houses, the people who are overassessing houses, the banks that are purposely closing their eyes to that, the rating agencies, up to two promoters of a hedge fund who are charged with essentially criminally overlooking the fact that the paper they were selling the public was worthless. There are 42 separate FBI task forces devoted to fighting that problem, but it's a problem that runs the gamut that I tried to describe. We've got over 400 defendants charged so far, and the investigation is certainly by no means closed. It's in full pace.
Another issue, you're aware that there are several bills pending dealing with the problem of gangs. One I've introduced takes a proactive approach to try to keep young people out of trouble to begin with. Other legislation, essentially, in my judgment, waits for young people to join a gang, mess up, get caught, and get overcharged with crimes. We already lock up more people in the United States than anywhere else on earth. My question is whether or not, and your website, actually, the Department of Justice website cites under the category of what works, many approaches that seem to be consistent with the Youth Promise Act that I've introduced. We don't have time now, but could you provide in writing any analysis that you may have done on what works and what doesn't work and how we ought to be addressing this, and the any analysis or help you might have to do as we evaluate the different approaches?
I think what works is a comprehensive approach. There's no one particular solution. What we try to do is to focus our efforts along with state and local governments, along with other agencies, in both enforcement, that is, we use the task force approach to enforcement, and we also use weed and seed programs and other community outreach programs. I was just present last night at a privately funded competition, essay competition, that was competed in by more than 120,000 youngsters on the subject of community violence. We're active in that. We help fund that. So we believe firmly that this requires a comprehensive approach. In the end, we are principally a law enforcement organization, but we do recognize the need for a comprehensive approach. We favor that. We do prevention.
And if you could, if you've done any in-depth analysis and can provide us guidance on that, that would be helpful. My next question is regards the federal prisons. We recently had to appropriate money in a supplemental appropriation to deal with what we believe to be a crisis in personnel in prisons. The prison industry program, federal prison industry program, has been widely supported by virtually all federal prison industry, federal prison personnel. Could you explain why the Department of Justice hasn't been more aggressive in promoting the program in Congress, opposing efforts to weaken the program, and if you could say something about the staffing levels generally, because there's some concern that the staffing levels are so low now that our prison guards may be in danger.
Well, I think I'm not supposed to express relief at a supplemental that's in excess of what was originally requested, but privately, in the privacy of this room, I'm satisfied that there was a supplemental, particularly with respect to the BOP, which took a major hit in connection with the budget, and I'm glad and gratified to see that. With regard to prison industries, that's an important program, not simply for the people who are in prison, but rather as a way of controlling the population. As you know, those jobs are not only good training, they're valued by the prisoners themselves, and they are an excellent control mechanism because loss of a job like that for infractions and for violence is a big risk. So giving that privilege of access to such a program and denial of it is a helpful way to control people in prison. It's not just for the good of, as you said, of the crooks. It's for the good of the guards. It's for the good of future victims who will not become future victims as a result of the fact that people learn valuable skills in that program. When I was a judge, I was a proponent of that program. I still am.
Now because of staffing level?
We think that we've got the situation under control, but it's barely under control. The prison population recently has changed, and it hasn't changed for the better. People are getting more violent. They are not responsive to even to warning gunshots that are fired when they start riots and so forth. And we've had an uptick in violence. So far, it's been under control. But a couple of weeks ago, I went out to attend the funeral of a guard who was killed out in California with a shank. A young man who had served 2 tours in Iraq, come out of the Navy, was building a career for himself. He was 2 weeks short of his 23rd birthday. It was a tragic situation. That's the first time in a dozen years that a guard has been killed, but I want it to be the last time. And I think we need to make greater efforts in that area. The fact is that the professionals in the Bureau of Prisons do an amazing job in the way they control those violent populations with a very small group of people. If you go into one of those institutions, it's remarkable how small the ratio is as between guards and prisoners. But we need to do more in that area, and we need to stop the kinds of incidents that I mentioned. We're concerned about it.
Howard Coble, a ranking member of the Intellectual Property Committee.
Thank you, Mr. Chairman. General, good to have you on the Hill.
Good to be
The
here.
distinguished ranking member from Texas commented on intellectual property, and I want to direct your attention to that issue. General, as you know, this committee has long sought to work with the department to strengthen the ability of law enforcement to deter, investigate, and prosecute intellectual property-related crimes. As you probably know, we overwhelmingly passed in the House earlier this year the bill prioritizing resources and organization for intellectual property. Some years ago, a department witness stated to this committee that there are known links between IP crime and organized crime and even terrorism. General, can you comment today on what evidence can be produced to link IP-related crimes with terrorist funding, and any specific details to known links? Now, it may be more appropriate to do that in writing, but could you do that?
I can do it in a general way. The fact is that we're facing, on an international level, more and more organized crime, and these folks will sell absolutely everything they can for as much as they can. One of the most valuable things that this country has is intellectual property. It's the engine that drives our economy. And there are foreign governments that are intent on getting into that intellectual property, and there are foreign non-governments in the form of terrorist organizations that are interested in getting into that intellectual property so that they can exploit it not only for its inherent worth, but also for its commercial worth. I will provide in writing further specific instances of that. But the fact is that everything from phony shoes and handbags on up has been offered for sale by people who are completely indiscriminate in who gets the proceeds as long as they make money along the way. And that has included people who are involved in or suspected of terrorist activity.
And if you could present additional details, we'd be appreciative to you for that.
I will do that.
General, earlier this year, President Bush signed the Second Chance Act into law. This legislation has broad support and I believe is a new approach to an old but alarming problem, that is prison overcrowding. Have you had an opportunity to review or to be briefed on this legislation? And
I'm sorry, go ahead.
Well, and do you agree with me that it's a good first step addressing the skyrocketing problem of recidivism, particularly of nonviolent offenders?
I agree that it's a good first step. The recidivism rate in federal prisons is a good deal lower than the recidivism rate overall in prisons, largely because we concern ourselves before people are released with putting them in programs that train them for release and with follow-up afterwards. And the Second Chance Act is an important part of that. We hope to lower the recidivism rate still further. And we think that that kind of legislation and that kind of outlook is a good way toward solving the kind of problem that Member Scott pointed out before, that we should be working on prevention at both ends, rather than simply on enforcement. Enforcement's an important part. That's what we do principally. But we can't lose sight of the fact that when prevention opportunities present themselves, as they do in that legislation, we have to follow up on it.
I concur, and I do believe that prison overcrowding may be one of the most pressing domestic problems facing us, and I furthermore believe it's probably more seriously involved in the local and state
It's much more serious on the state level than it is on the federal level. We avail ourselves not only of the facilities that we have, but also of rented space in state and local institutions and in some private institutions that run prisons, if you will, or detention facilities on a private basis when they are reviewed and approved for standards. So far, we've been able to hold up and do that. But so far is so far. We want to make sure that we've got enough resources to continue to do it.
I thank you, General. Mr. Chairman, I want you to take note. I am beating the illumination of the red light.
You usually do.
Thank you, sir.
Thank you. The chair recognizes the chairman of the Oversight Committee of the Finance Committee, but a senior member of Judiciary as well, Mel Watt of North Carolina.
Thank you, Mr. Chairman. Mr. Attorney General, back on April 23rd of this year, the director of the FBI was before this committee, and I asked him about a particular referral that had been made, and we finally got a response back from him just 2 days ago, really, in which he says this: regarding the referral made to our Charlotte field office, we confirmed that in October 2006, the field office was forwarded a letter which the North Carolina State Bureau of Investigation received from state lawmakers requesting an investigation into AERO, A-E-R-O contractors. The letter alleged that AERO Contractors has been identified as a participant in the CIA-sponsored rendition program, which has flown persons detained in various countries, including the United States, to overseas torture sites. We consulted with our field office and the Department of Justice, and at this time we do not have an open investigation regarding the allegation. I've reviewed the jurisdiction of the various, I think there are 11 or 12 divisions under the Attorney General, and there's a National Security Division, there's a Criminal Division, and I guess my question is, first, would it be a violation of law for a contractor to fly persons detained in to overseas torture sites?
The country has enforced laws that require that before people are sent abroad, we receive assurances from foreign governments that they will not be abused. That said, I am not familiar with either the case or the program that you refer to, and as you point out, this correspondence goes back to 2006, which is essentially 2 years before I got here.
Well, but the concern I have is that I asked the FBI director to give me all the information. We got one paragraph about it, and I still don't know anything more. We know an investigation, a letter asking for an investigation was made. We know there is not a current active investigation. That's what the director's letter says. But still, we don't know what happened in the interim, whether they concluded that there was no basis for the investigation, whether the department looked the other way, whether there's any, I don't even know whether you all think sending somebody out of the country for rendition to a torture site would be a violation of any law as it stands.
I would like to take a look at the case before I comment on the case.
Okay, well, if you would do that.
One thing I've learned from past bitter experience.
Yeah, and that's, that's exactly what we asked the director of the FBI to do. Unfortunately, when we got the response a number of months later, we don't know anything more or very little more than I had told him. I mean, I had told him that there was a referral, but he wrote me a letter back confirming that there was a referral.
Bob Mueller is a very diligent guy, but in this case, I hope to be able to perform better and outdo him.
I'd certainly appreciate that, and in the process,
and a very able person. I mean,
it'd be nice to know if the department thought that flying somebody out of the country to rendering them to a torture site would be a violation of law. But I won't ask you for that opinion right now, but I hope you'll include that
I will include
when you correspond with it. The one part of the voting process this year that a number of people are expressing concerns about, because we believe there will be a voting pattern that will be substantially different than there has historically been. And one of the concerns we have is that nobody is really anticipating those demographic shifts in the voting patterns that we anticipate will happen. Does your task force that you've been working with the states on, is that part of what you're doing? And if not, will you include it to make sure that there are enough machines, enough personnel, enough trained people that know what they're doing to get people processed without standing in line for hours on end?
the short answer to your question is yes. We anticipate a much higher turnout this year because of increased enrollment this year, as you point out, and we're doing what we can. We have to keep in mind, as we do that this effort is organized principally by state and local governments. What we need to do is to make sure that they realize and understand that where there is increased enrollment, they know it, and that they're doing what they can to get the facilities that they need to handle the increased enrollment and handle the increased turnout, if in fact there is increased turnout. That's what we're doing, and we're trying to do everything we can, including to make information available not only to the state and local governments, but to particular groups with an interest in making sure that people turn out so that they know what the rules are and aren't, and know what they can and can't do, and police their state and local groups and make us aware of when there are shortcomings. It's kind of a two-way street.
Thank you, Mr. Chairman. My time has expired. I yield back.
The senior member of Judiciary from California, Elton Gallagher.
Thank you very much, Mr. Chairman. Welcome, Attorney General Mukasey.
Thank you.
Recently, during different debates that we've had on immigration, we found that the FBI does various forms of background checks, name checks, and so on and so forth, and there is a backlog. Can you tell us how the FBI has addressed the backlog in the name check or other background checks?
They're addressing the backlog in the one way you can address it, which is by throwing more personnel at it, and they have, I think, gotten it down, way down, I believe. I think it's down to something like 90 or 120 days. I'm not precisely sure, but I think it is. I know it is way below what it was before, but we recognize that that was a problem. We're addressing it, and we understand it, and they understand it, and they're putting more people on it to make sure that they do the background checks.
Is there currently a backlog in the criminal background check of legal aliens?
There is currently a background check. There's currently some backlog across the board. be it criminal check, be it just check on background. That includes past criminal background.
This may be a little bit more difficult, but you know, in recent months and actually recent years, there's been a lot of discussion about comprehensive immigration reform. Some of us think that's code word for amnesty. But in the event that that should take place, and depending on who you talk with, I think most reasonable people would say this could account for about 20 million people. Is it logistically possible to do a background check on that many people?
Now?
Well,
no. I mean, it's logistically possible, I suppose, over an extended period of time. But if you throw 20 million more people into the system, is it going to stagger the system? Yes.
I think that was probably a rhetorical question. In any event, one other question I have relating to immigration. We have, in fact, I met with a former Attorney General in a previous administration several years ago and was discussing the issue of sponsorship of legal aliens. When you have an immigrant coming to the country and they have a sponsor, they sign a statement of economic responsibility or financial responsibility. Do you view that commitment, that document they sign, as a legal and binding contract or as a moral commitment?
I believe it is binding. I think if somebody says, I'm going to be financially responsible for somebody, what that means is they're going to be financially responsible for somebody. That's what I understand it to mean.
Would you be kind enough to perhaps in the near future have your staff give us some type of a recap of how many folks have actually been prosecuted for not
stepping up and
not taking that responsibility, and whether or not we're actually pursuing it? I could give you examples in my own district about people that are in the seven figures that bring someone here that within 6 months a parent or a brother or whoever they brought here is on federal benefits getting hearing aids that cost over $5,000, and nothing is done about it. So in any event, I'd just like to know if in fact, with all the other things that your department is challenged with, whether or not this is an issue that's taken seriously.
Yeah, in fairness, I think this is in some part a responsibility of DHS, which has, as you know, immigration control. But let me find out.
Of course, when I had this discussion before, we didn't have a DHS, but we do now.
I understand. There's been a sundering of responsibility to a certain extent here. Let me find out what part of it we've got, what part of it they've got, and see if we can straighten it out.
Thank you very much, Mr. Chairman.
Thank you. Chairwoman Zoe Lofgren, Chair of the Immigration Committee.
Thank you, Mr. Chairman, and Mr. Attorney General. It's good to see you. I have some questions really about our policies on prosecution of misdemeanor immigration measures and how that is impacting the other prosecution priorities of the government. We received information a few weeks ago in a subcommittee hearing with U.S. attorneys that in the southwest border region there had been a very substantial tens of thousands of increases in misdemeanor prosecutions for immigration violations and a nearly 40% decrease in prosecution of organized crime. To me, that seemed like not a good trade-off in terms of the standards. So I'm wondering, TRAC, and I know that the department doesn't always agree with TRAC, has told us that 58% of all prosecutions in April of this year were for immigration-related matters, with only 13% for drug trafficking, and that 58% of all criminal prosecutions is mostly for misdemeanor immigration crimes. Can you address this?
I can address it in this way. Yes, we've had an increase in misdemeanor prosecutions. The strategy across the border is a varied strategy. It is not one size fits all. Part of that strategy involves prosecution. And in the districts where we found an increase in prosecution, we have also found a decrease in infiltration, that is, a decrease in the number of illegals coming across the border. That, to me, suggests a relationship. I don't by any means buy into the idea of a trade-off as between immigration prosecutions and drug prosecutions. I agree with you.
Well, if I can, Mr. Attorney General, the statistics we got were, from the department, and what they told us is that there had been an increase, a substantial increase, and it was accompanied at the same time by a tremendous decrease in organized crime prosecutions. And I have heard from local prosecutors that DEA agents are now turning to local police for some of their drug prosecutions because they can't get warrants through the U.S. Attorney's Office. It's taking 6 months, which for a drug prosecution it just doesn't work. And because the U.S. Attorney's offices are so busy with prosecution of nannies and busboys that they can't get to court in a timely fashion to get these warrants in the fight against these drug cartels. That's what local prosecutors are telling me. Can you address that?
In fairness, I think it's a mistake to say that we are not prosecuting drug dealers and we are prosecuting nannies and busboys. Some of the smaller drug cases are prosecuted in state and local courts. However, we do prosecute drug cases, even low-level drug cases, where it appears that people are bringing drugs in relatively small amounts, are putting those together with other amounts and essentially packaging them up for larger shipment. So we try to prosecute the more serious drug cases as well as the immigration cases to keep the numbers down and to control a problem that I think we all recognize, which is unlawful immigration.
Well, I appreciate that's your philosophy. I don't think the statistics in your department back up that philosophy. Let me talk to you about the federal circuit courts, because they have been in touch. As you know, immigration appeals are the single largest number of cases in the circuits. The Second and Ninth Circuit, that's 40% of their overall docket is immigration appeals. And the circuits have actually organized to say, we need to do something about this. They really believe, and I think they're right, that the caseload expansion at the circuit courts is a result of the BIA streamlining procedures that former Attorney General Ashcroft implemented in 2002, which basically eliminated any effective, meaningful review for immigration appeals, which just shoved it up to the circuits. What are you doing or planning to do to relieve this burden on the circuits?
We are trying to systemize and organize the way in which immigration appeals are handled, and it's my understanding, for example, that in the Second Circuit, which is the one that I come from, they have organized the docket of immigration cases in such a way that some of them are handled summarily, that is, without argument, others not, depending on the underlying merits of the case. They've managed to screen and handle them that way.
If I could, I know my time has expired. I think this is really an emergency for our circuits, and I am sure that you're sensitive to it. The committee that the circuits have organized has indicated to me that the answer is not with the circuits. The answer is to look at what caused this shift to the circuits, and it's because if you've got bad cases, they're going to be heard somewhere. If somebody's going to be killed because their asylum appeal was erroneously denied, they're not going to just pass on that because it's too serious. And so if you don't have a meaningful BIA process, which we don't, then we're going to have this spill up to the circuits, and it's overwhelming them, and it's not the appropriate format, it seems to me.
My experience with BIA cases has been that they are resolved on the merits in a serious way. I don't see the BIA rubber stamping them one way or the other.
Well, that's not what the circuit courts believe. I yield back, Mr. Chairman. Thank you.
Steve Shabbat, formerly ranking member on the Antitrust Task Force Committee of Judiciary, now ranking on the Small Business Administration and still a member of Judiciary Committee.
Thank you, Mr. Chairman. General Mukasey, I want to follow up on some questioning back in February regarding regarding Delta Airlines and its announcement to merge with Northwest Airlines. Mergers within the airline industry are treated with a great deal of speculation because of the impact that such a move has on consumers, particularly now with rising fuel prices, in terms of limited flights and increased fares, and in addition, the economic toll that it can have on cities and regions in terms of their ability to bring businesses and development into an area. My question to you is how is the department examining the merger, and what factors are you examining, and when do you expect a decision on that merger?
But the short answer to your question is carefully, and the Antitrust Division has been addressing that merger in particular in a very sensitive way. They've got their own economists on staff who weigh the economic effect of the merger as against the economic effect of having companies continue in business, neither of which can survive alone. And so what they try to do is to balance the one against the other and see whether the merger promotes competition, enhances the health of the surviving entity or the combined entity, and serves consumers better. Those are the elements that they consider, and they consider them carefully, and they understand that this is an exigent matter. Mm-hmm. They're working hard on it. I meet with them regularly. But since it is a hard matter, they want to make sure they get it right the first time.
Okay, thank you. And related to the Delta merger, members of the Ohio delegation sent a letter to you last month and to the Assistant Attorney General for Antitrust, Thomas O. Barnett, last week, expressing concerns with DHL's decision to enter into a contract with United Parcel Service. That agreement would allow UPS, one of DHL's principal competitors, to provide DHL's delivery services in North America. To make a long story short, implementation of this agreement could impact Ohioans who are employed by companies already providing these services for DHL, as well as consumers nationwide who are purchasers of these delivery services. Understanding the implications that this agreement has for the state of Ohio, and in fact for the nation, my question is how will the Department of Justice treat this agreement, and what factors would your office be examining to ensure that the market remains competitive and consumers protected? And I would assume your answer is somewhat similar to the first, but there it is.
It's very similar to the first. I think we would consider, obviously, what alternatives are available to consumers to reliance on either UPS or DHL. FedEx comes to mind, although that's only because that's one that I'm familiar with. But the effect on consumers and the economic effect of the merger is going to be something that they consider. That includes jobs. But the first that I've heard of it, I think, was yesterday when the letter came to my attention. I've not reviewed that particular one with the Antitrust Division, but I have no doubt that they are giving that the kind of consideration that they're giving to the rather larger merger that you've referred to, which I have discussed with them.
Okay. Thank you very much. And finally, on June 25th, so just about a month ago, the U.S. Supreme Court struck down a Louisiana state law authorizing the death penalty for child rape cases. In overturning the death sentence, the court examined the Eighth Amendment under its evolving standards of decency standard, specifically focusing on national trends relating to the death penalty in child rape cases. The court claimed that there is a national consensus against the death penalty for child rape cases. In my opinion, nothing could be further from the truth. In fact, Congress 2 years ago authorized the death penalty for child rapists under the Uniform Code of Military Justice. And in 2007, President Bush issued Executive Order 13447 codifying this provision in the 2008 Manual for Courts Martial. Just yesterday, the state of Louisiana filed a petition for rehearing in the case, and I have introduced a constitutional amendment along with a number of my colleagues, Rick Keller, Lamar Smith, Tom Feeney, and others that would clearly state that the death penalty for a child rape is not cruel and unusual punishment, and I'd be very pleased to hear any input you could give us on that.
Well, first of all, the fact that that was in the Uniform Code of Military Justice is something that we missed, and I regret that, and I take some, but frankly very little consolation from the fact that all 9 Supreme Court justices missed it, all of their clerks missed it, and the parties missed it. That was pointed out by somebody with a particular interest in military law who found it later on. The fact that the that leaves us in a position of not being able to petition independently. The fact that Louisiana has petitioned gives us the opportunity to join in that petition. To my knowledge, the decision about whether to join in it or not has not yet been made, but is under consideration. That's what I know about that.
Okay, thank you very much, and I'd urge you to join that because I think it's unconscionable that those that commit perhaps one of the most despicable acts possible, the rape of a child, can't get the ultimate penalty because of a 5-4 vote in the U.S. Supreme Court, and I think that should be reversed as quickly as possible. Thank you very much.
The distinguished gentlelady from Texas, Chair of the Transportation Subcommittee and Homeland Security and an officer in the Congressional Black Caucus, Sheila Jackson Lee, Houston, Texas.
Mr. Chairman, thank you, and to the ranking member. It is an important time that we spend with you, Mr. Attorney General, on our oversight duties, and for hoping that the word that I use does not suggest that there is no work at the Department of Justice, but let me just say there's a certain order and calm that you brought to the Department of Justice, and we applaud you, I do, for, I hope, the hard work that is going on there. You've heard the many concerns of my colleagues, and I'm going to add to them and try to speak as quickly as I can to try to frame the concerns that I have. This is the role of the Department of Justice, I think, is the arm of justice for the nation. And I note that the FY09 budget on civil rights is $123 million. Sounds like a lot, but it's less than $1 per American, and I believe all Americans deserve the right to civil liberties. So let me quickly put some things on the record. I want to express concern, and I know overlapping jurisdictions on the random ICE raids that generated the arrest of American citizens because their last name happened to be, in many instances in Texas, Hispanic. And I would ask for a report back from Department of Justice on how they are coordinating with these ICE raids that haul in Americans under the pretense of immigration reform. Let me quickly also suggest that we have a broken watch list process. I want to commend an individual who is a medical doctor who has been trying to become a citizen since 2004, and it is now 2008, and we believe that we know that it is a question of the watch list verification. Another individual that had a sex change is a functioning, working individual, abiding by the law, been trying to become a citizen since 1203, and they too are in the mix of this confusion of the watch list. So I would like to put into the record, Mr. Chairman, I ask unanimous consent to put into the record, Mr. General Mukasey, the letter that I sent to you on July 22, 2008, to ask for an investigation of the FBI watch list and its progress. You might want to comment briefly, but I want to put this in the record. Specifically deals with the likes of Congressman John Lewis, but also Drew Griffin of CNN, who came on the watch list after an investigation.
Without objection, so ordered.
I also want to put into the record February 7, 2008, a letter dealing with the imams in the Minneapolis-St. Paul airport as to why these imams were removed, arrested, and detained. I understand that they have a finding of discrimination. I'd like to know what the Department of Justice is doing that. Mr. Chairman, I ask unanimous consent to put that in the record.
Without objection, so ordered.
Now let me get to where I will cease so that you can answer these questions. We have had a series of incidences under the criminal laws of this nation that have shown that we need improvement. Mr. General, I've mentioned that the oversight of the long arm of the government can bring about light at the end of the tunnel. Gina 6, I refer you to. The Sean Bell case, I refer you to. The recent tasering of a black man in Winfield, Louisiana, and then to Harris County, where we have found that there have been 101 deaths from January 2001 to December 2006. We just had the additional loss of a Miss Saveda who died in the jail from a infected knee, having begged for medical treatment and having not received it. I'm going to put into the record a May 7, 2007 letter that I have given to you previously, asked unanimous consent.
Without objection, so ordered.
A February 7, 2008 letter regarding the district attorney in Harris County, and I briefly read to you This person is alleged to have repeatedly sent racist and sexual emails in his actions and the cases which he prosecuted. We ask simply for this to be reviewed by on the basis of prosecutorial misconduct and abuse, civil rights violations, and the proclivity to remove black jurors. We got a letter back from the Department of Justice indicating that that was not something that you would review, and I thought that had to do with civil rights. So I would ask Mr. Attorney General, one, what is the amount of money and staff and counsel that you're utilizing to help purge out the bad apples in the nation's criminal justice system as it relates to the violation of civil rights of Americans? And two, what are we doing with respect to the national security investigations of individuals who sometimes seem to be targeted because of racial, ethnic, sexual, gender, or otherwise? And I'd appreciate your answer.
I cannot enumerate for you now a specific amount of money being devoted to the problem that you raise. The fact is that we devote our resources to, across the board, to civil rights problems, and we've had a phenomenal success rate. Criminal prosecutions are up. The level of our success in appellate cases is up. The number of voting rights cases that we've brought is up. We bring Title VII cases to achieve the maximum amount of impact. We're doing this across the board. With respect to the, I think it was the Harris County Jail situation that you...
And the District Attorney's Office, which your office,
the DA's office
indicated that they couldn't respond.
If criminal evidence comes to hand that warrants a prosecution of that district attorney...
Or civil rights?
Or civil rights, who, by the way, is no longer in that position.
I understand.
He is now an ex-DA, and it sounds like he deserves to be an ex-DA. We will pursue that. But with regard to the Harris County Jail investigation, that is ongoing. It's bound to be a long-term thing because it involves revisiting the facility, evaluating all of its treatment, medical care, food, space, and the like, and it's likely to take quite some period of time. But there's an active inquiry into the conditions in Harris County, and that's due in no small part to the fact that you are involved in that and have offered us both advice and leads in that. And although you've been somewhat critical, I can't do anything but say that I'm grateful for the fact that you're involved in it.
I'll just simply say the District Attorney's Office, you've articulated the history of that office, but I think the question for the Justice Department will be pattern and practice. And I would ask respectfully, Mr. General Mukasey, that be looked again, because I mentioned the elimination of minority jurors consistently, and I think that warrants a broader look-see because we're talking about the infrastructure of the justice system.
I will get back to you with respect to that one.
And thank you.
The Chair recognizes Dan Lundgren, who is the only former Attorney General of a state on the Judiciary Committee, and he's senior of the three other former Attorney Generals that are here.
Thank you very much, Mr. Chairman. Thank you for appearing before us, Mr. Attorney General. Mr. Attorney General, a year and a half ago, the Foreign Intelligence Surveillance Court made a ruling in which it indicated that new circumstances overwhelmed the FISA law and basically invited the Congress to deal with that issue. It took us a year and a half to do that, during which time I think we lost valuable opportunities for intelligence. Now you have come before us to refer us to the recent Supreme Court case dealing with unlawful enemy combatants and this new right they have to habeas corpus, a right that had never been seen before in the history of the United States, but nonetheless one that, in the involving sense of wisdom, the U.S. Supreme Court has found. In the speech you gave yesterday, or yesterday or the day before, AEI.
Day before, I think.
You spoke at some length about this, and in the middle of your speech you said one of the questions that had to be answered was whether a federal court will be able to order that enemy combatants detained at Guantanamo Bay be released into the United States. You then went on to say the Supreme Court stated that a federal trial court must be able to order at least the conditional release of a detainee who successfully challenges his detention. But what does it mean to order the release of a foreign national captured abroad and detained at a secure United States military base in Cuba? Will the courts be able to order the government to bring detainees into the United States and release them here rather than transferring them to another nation? And you further indicated that the court has invited the Congress to act on that. And so I wish you would go a little bit further than you did in your opening statement about the urgency of the matter for Congress to address this and the seriousness of the questions that you asked here, because it seems to me those are unsettled questions. Whether the courts would be able to order the government to bring detainees in the United States and release them here. Clearly that has not been decided, yet I believe the court is inviting the Congress to outline the parameters of that, and I would suggest make it impossible for that to happen.
The court has left that matter open, and but it has said that at the end of the day, it must be open to a decision maker to direct release. Now, the fact is that all of these people, every single one of them, are aliens captured abroad in essentially battle conditions, who have absolutely no right to be here, and there's no good reason to have a court bring somebody here for purposes of release and release into our communities people who could pose a significant danger. We want that particular possibility cut off. We don't want to have to face it. We shouldn't have to face it. And if people are brought here for hearings or are brought here as witnesses, they can, simply by coming here, acquire rights that they did not have abroad. You recall that there was an extraordinary effort to keep Haitians from coming here, to keep people in the Mariel boat lift from coming here when they were released from Cuba, and for very good reason. And that is, if they set foot on American soil, there are matters that are at issue that were not at issue beforehand. We don't think they should be put at issue.
You also mentioned in your speech the question of whether or not American military people on the battlefield would be subject to coming to a hearing, whether or not their testimony would be required, the kinds of evidence keeping that would be required under normal circumstances, and how that applies to the battlefield. I presume you're suggesting that Congress ought to deal with that issue as well.
I am. The court left it open specifically and said that this was to be approached in a practical way. Courts don't have the ability to gather facts on their own. Congress has that ability. Courts don't have the collective expertise that Congress has or that the executive can provide in assisting in drafting that legislation. Courts don't have it. Congress and the executive does. And if anyone should step into this, it's Congress with the assistance of the executive, and that's what we hope to do.
As I understand, we have over 200 people held currently at Guantanamo. This is ongoing. In other words,
down from 775.
Right. But this is ongoing, requiring Congress to act sooner rather than later.
Correct. Another thing the Supreme Court said is that this process had to go ahead quickly, and it is going ahead quickly. And the quicker it goes ahead, the more likely it becomes that there may be inconsistent results reached and situations created that could be stopped with intelligent legislation. Intelligent legislation can do two things. It can both speed up the process by assuring consistency, and it can assure that undesirable results are avoided.
I hope you haven't assumed facts not in evidence. That is, that we're capable of producing intelligent legislation. I hope that's not the case.
I think they are in evidence. Congress acted very quickly to pass the Protect America Act. It acted very quickly to enact the authorization of the use of military force. It acts quickly when it puts its collective mind to it. I don't want to sit here and preach. I mean, that's not what I'm here for. But the fact is that the capacity is here, and the intelligence is here.
I appreciate that very much. I yield back the balance of my time.
Chair recognizes the gentlelady from California, Maxine Waters, who chairs the Housing Subcommittee and Finance, and is a member of 3 subcommittees on Judiciary.
Thank you very much, Mr. Chairman. I appreciate the fact that you're always making available to us the heads of our agencies and departments that are responsible for important areas of government. And I'd like to thank Mr. Mukasey for being here today. The Justice Department has a responsibility of enforcing civil rights, investigating complaints of civil rights violations, the Voting Rights Act, fair housing, Title IX, enforcing discrimination complaints for those who are disabled, and of course age discrimination is one of the areas that you have responsibility for. I would like to know, what do you know about the problem of the discrimination complaints within your own department? If we're to have confidence that you can do the work that is mandated by law, I want to know why you continue to have so many discrimination complaints, what you understand about those complaints, how many are still pending. What have you proposed any initiative to deal with the problem? What are you doing to recruit and outreach to help cure the disparity? You have 12,000 agents. Less than 5% of them are African American. Does this problem cause you any embarrassment? And if so, what can you do about it? What are you going to do about it? What do you
When you
know
refer to
about
12,000 agents, you mean 12,000 FBI agents?
I have 12,000 agents serving in the FBI.
That corresponds
FBI.
roughly to the number of FBI agents.
Yes.
My experience has been, through direct observation, that FBI is engaged in significant outreach, and that more and more FBI agents are being recruited from within the African American community.
Do you have the numbers?
I don't have the numbers. I can get them for you.
I would appreciate that. You have discrimination complaints. How many are pending in the department?
I don't know the precise number that are pending. There's one that I'm familiar with that's in litigation that I can't really comment on. But my sense is that, my sense is different from yours, i.e. that there is not a large number of them. Let me go back and check. I know of one case that's in litigation.
When you talk about recruitment, could you describe your outreach and recruitment efforts?
We go to universities, we go to schools, we evaluate applications on the merits. We make it well known that we're looking for talented people.
Do you feel you have a problem?
We can always do more.
Do you have a problem?
We can always do more.
Are you satisfied that, aside from the kind of generic answer of you can always do more, that you don't have that many complaints, they're not that serious, and you don't need to take any special initiatives? If you can always do more, what more are you doing? What more do you propose to do?
I'm never satisfied. I'm not in the business of being satisfied. I'm in the business of looking for ways to recruit talented people from all communities. We've been doing that. I'm going to get you the numbers on the FBI, and if you have any particular cases, I'm happy to review them.
No, I would like to ask our chairman if we could make a request from this committee to get a list of all of the discrimination complaints and the status of those complaints so that we can decide, and I could impose upon you, Mr. Chairman, to see if we need to do a hearing about
these discrimination
those
complaints within the Civil Rights Division?
There are complaints
Or within the Department of
within the
Justice.
department. Discrimination complaints from agents, African American agents, from women against the department and your discriminatory practices there in the department.
Somewhat broadened the target, but whatever is requested, if we can provide it, we'll provide it.
Would the gentlelady yield? Because
Yes, I would yield.
I would be willing to review that list when it's sent to you.
I appreciate that. That's probably very important that we get the actual information. Mr. Mukasey is new, and he perhaps don't know in depth the the problem that exists.
I'm not taking refuge behind the fact that I'm new. I'm going to take a look at it, and it may provide a subject for discussion in a meeting that I'm going to have.
Mr. Chairman, I am being kind to provide him with an excuse for not knowing the information that I've asked him today. So whatever the reason is, we need that information, and I thank you, and I yield back the balance of my time.
Bob Goodlett, Chairman Emeritus of Agriculture and distinguished member of the committee.
Well, thank you, Mr. Chairman. Thank you for holding this hearing. And Attorney General Mukasey, welcome. We are very pleased to have you here. And I also want to thank you for your commitment to protecting our elections process by aggressively prosecuting voter fraud cases. I wonder how your efforts are going, and do you agree that it's crucial that we ensure that U.S. citizens' votes are not diluted by those unauthorized to vote, including illegal aliens?
I think it's crucial that we ensure it. I think that one way in which we have helped assure it is assuring that proper identification is required before somebody can vote. Obviously, when evidence presents itself that people are here unlawfully, they are apprehended and deported.
Well, thank you. And recent experience under Indiana's voter ID law seems to show that such laws do not diminish voter turnout. On the contrary, they can actually increase voter turnout. As was recently reported, voter turnout among Democrats improved slightly last year in Indiana despite a new law requiring voters to show photo identification at the polls. Jeffrey D. Milio, a professor at the University of Missouri, compared the 2006 midterm elections, the first since Indiana's law was enacted, to the 2002 midterm elections, and said voter turnout increased about 2 percentage points. He said the increase was consistent across counties with the highest percentage of Democrats. So do you think that this increased turnout could be explained by the fact that securing voter ID laws gives legal voters the security of knowing that their vote will count and that it will not be diluted?
I'm not technically trained, so I don't want to speculate on a possible relationship. I think all that study shows is that you don't cut down the number of voters simply by requiring that people have to show ID. Whether there's a cause and effect relationship is for people who are much more schooled in statistics and sociology than I am.
I agree. Section 642 of the Illegal Immigration Reform and Immigrant Responsibility Act of 1996 bars state and local governments from restricting their law enforcement officers from communicating with the Department of Homeland Security about the immigration status of individuals. Despite this law, many sanctuary cities continue to prohibit law enforcement from checking the immigration status of criminal aliens that they encounter. The results can be tragic. There have been many reported cases where the immigration status of criminal aliens was not checked because of sanctuary policies, and they were released back into society to murder American citizens. What steps are you taking to enforce Section 642 and to stop cities from using sanctuary policies?
We are trying to police unlawful aliens in this country. We're doing our best to conduct controlled operations along with the Department of Homeland Security when we find them located in a particular place. That said, I've said on prior occasions that I can understand the dilemma posed when unlawful aliens essentially present an attractive victim pool for people who know that they won't file complaints. And there's a balance to be struck here, but we're certainly alive to the need for enforcement, and we engage in it actively.
And that dilemma that you face could be enhanced if you had the cooperation of communities rather than some communities refusing to cooperate with the Department of Homeland Security or the Justice Department in enforcing our criminal laws.
Precisely.
Thank you, Attorney General. In April of this year, you announced the allocation of additional resources for prosecuting felony and misdemeanor immigration-related violations such as human trafficking and drug smuggling, with $7 million provided to hire 64 assistant U.S. attorneys and 35 support staff assigned to the southwest border. U.S. attorneys' offices which prosecute the majority of the country's felony immigration cases. For fiscal year 2009, the Department is requesting another $8.4 million to add another 50 attorneys along the border. With these increased resources, will you be placing increased emphasis on the prosecution of misdemeanor and felony immigration cases?
We will be able to address this problem as we have been addressing it in a flexible sort of way, including increased prosecution, which, as I said, has led to reduced infiltration. We have more prosecutions, less infiltration in each of the districts across the border. We don't use precisely the same approach in each of the districts across the border. It's not one size fits all, because one size doesn't fit all. There are places where there are greater numbers that, if fully prosecuted, would overwhelm the system because there simply aren't enough judges, lawyers, bed space, and marshals. But we try to address each problem and each district to meet that district's needs.
Well, thank you. I agree with that assessment. I think Americans are starting to see some results along the border. I think more needs to be done, and more needs to be done in the interior of the country, but I encourage you to pursue those efforts, and thank you again for being here today. I yield back, Mr. Chairman.
Bob Wexler, Florida, member of the Intellectual Property Subcommittee.
Thank you very much, Mr. Chairman. Thank you, Mr. Attorney General, for appearing before us. I am hopeful that you, Mr. Attorney General, can somehow explain to this committee and to the American people how this administration effectively nullified the constitutional power of Congress to investigate actions of the executive branch, and how this administration has effectively rendered meaningless our power to seek and subpoena executive branch witnesses. Unfortunately, your actions thus far have enabled this president to assert this unprecedented abuse of executive privilege claims and the outright refusal of administration officials to come before Congress. I would like to specifically discuss with you the interview Vice President Cheney held with the FBI regarding the CIA leak investigation. In a demonstration of just how far you have stretched the definition of executive privilege, you declared that those FBI interviews were, quote, internal White House deliberations, end quote, and thus exempt from congressional oversight. These FBI interviews would seem to be nothing of the sort, and they would seem to have zero relation to any official White House business or federal policy. These are transcripts of FBI investigators interviewing Vice President Cheney. Nothing more, nothing less. So my question respectfully, Mr. Attorney General, is does your Justice Department consider all FBI investigators to be part of the White House? And by your logic, is there any way, any conceivable way, that the White House could in fact be investigated without triggering executive privilege?
Let me explain the problem as follows. The FBI 302s that you refer to, which by the way are not transcripts, they are reports by FBI agents on their conversations with particular people. The 302s that you refer to are reports on conversations with the Vice President. Those conversations concerned conversations that he had internally with respect to matters that were at the heart of the notion of executive privilege, i.e. conversations relating to whether the President was accurate or inaccurate in his comments in the State of the Union and related matters. That was the subject of those 302s. The fact that those conversations happened to be recorded in 302s doesn't change the protection afforded to them. That's our view. And I think that principle is not my invention. It's nicely illustrated in a pair of cases involving the Nixon tapes where an objection based on executive privilege was sustained in response to a congressional subpoena, whereas an objection based on executive privilege was not sustained in response to a demand on a subpoena by a prosecutor. Those two cases could not stand side by side were it not for there being that distinction.
Are you asserting that the FBI did not inquire with the Vice President with respect to his role in the outing of a covert CIA agent?
I'm not going to disclose the substance of the FBI's inquiries beyond saying that the subject of those inquiries involved core executive privilege concerns which the President invoked.
If the Vice President of the United States did in fact participate in the outing of a covert CIA agent, is it your position that that involves the core actions of the Vice President?
I should point out that your question embodies a counterfactual assumption because the prosecutor in that case closed that case by saying that no further investigation was necessary.
What is your definition of internal White House deliberations? What qualifies?
What qualifies for executive privilege? Deliberations between the President and those immediately around him and the gathering of information by him for the purpose of making decisions.
So a discussion with the Vice President with FBI agents under that definition would only qualify to the extent he is talking about conversations that the President had. Is that correct?
Conversations that were had within the executive generally for the purpose of advising the President.
But clearly, you tell me otherwise. Whether or not the Vice President participated in a scheme to out a CIA agent, would that be covered by executive privilege?
The Vice President's participation, yes or no, was the subject of inquiry by a prosecutor who
I understand
concluded that there was
but
no basis.
Does it qualify for executive privilege?
In the abstract, no.
Thank you, Mr. Chairman. My time has expired.
The chair recognizes Rick Keller, who serves on 3 subcommittees on judiciary. The gentleman from Florida is recognized.
Thank you, Mr. Chairman, and thank you, General Mukasey, for being here today. We very much appreciate it. I'm going to ask you about 2 subject areas. I'm over here. First, I want to ask you about the media shield issues, and second, touch on violent crime. With respect to media shield issue, I've read your testimony today. I know that you and the Bush administration have expressed concerns about the media shield bill. I've worked very closely with the authors of this legislation to come up with fair compromise language that helped to win overwhelming bipartisan support on this Judiciary Committee and in the full House. Since the sensible exceptions that we've come up with, such as not allowing reporters to withhold information that could prevent crime, terrorism, or harm national security, hasn't been enough to satisfy the Bush administration enough to support the media shield bill, I'm curious myself about what it would take to have a bill that would be acceptable. So my question to you is there any version of the federal media shield bill that you would find acceptable enough to recommend to President Bush that he not veto it?
With great respect, there's nothing that I've seen in the media shield bill as presented that would allow for the sufficient protection of classified information, for the sufficient protection of the security of this country. In my view, the media shield bill in the large is a solution in search of a problem. We have a procedure in place for the protection of subpoenas against reporters. United States attorneys are not free simply to do that without the permission of the Attorney General. We've had less than 24 cases in which such subpoenas have issued since 1993.
Well, Mr. Attorney General, I would submit to you that there is language in there that specifically deals with the leaking of classified national security information.
There is, in fact, a higher standard for prosecuting a leak case than there is for any other case in that statute. And it would provide not protection for reporters, it would provide protection for leakers.
Right. Well, you're aware that the ranking members of the Intelligence Committee, along with the chairman of the Intelligence Committee, Republicans and Democrats, along with the leaders, Republican and Democrats, of the Armed Services Committee, felt that language dealing with the national security protections was sufficient enough that it justified them voting for it.
I don't know what they felt or didn't feel. I know what's in the bill. And what's in the bill, for example, requires a showing that classified information was properly classified and that the person who leaked it had authorized possession of it. If somebody wants to leak classified information, it is child's play for that person to take that information, give it to somebody who's not authorized to leak it, and then the investigation ends.
All right, let's focus on what we can agree on, because I don't want to quarrel with you, but I'm trying to resolve this issue.
That's what's in the bill.
Right, but we can agree that 398 House members voted for it. I think we can agree that both Senator Obama and Senator McCain said they would sign the bill, and I think we could agree that one of those two men is going to be the next President of the United States. And so you would agree with all three of those facts?
I would agree with all of those facts, and I would also agree that 10 angels swearing on Bibles that that bill was harmless would not change the provisions that are in it.
So back to my original questions, if you got less than 6 months on the clock here with the end of the Bush administration, will you commit today to sitting down with our congressional leaders to try to fashion a compromise relating to these national security issues that would ultimately result in you being able to recommend that the President sign the bill, or in the alternative, is there no bill that you would recommend being signed?
I'm in the same position as a socialist candidate for president named Eugene Debs, who said, I'll talk to anybody who will talk to me. I will sit down with anybody who wants to sit down and have a serious conversation about what can be done and what can't be done. But first we need to talk about what's there. And what's there is not acceptable.
All right.
For the reasons I've started to explain.
Okay.
I would be happy to continue to explain.
And if there is language that's acceptable to you that provides the protections for national security, would you then be able to position to recommend it?
If anybody can come up with language that's acceptable, that protects national security, that allows us to get information when there's serious indication of an impending crime, then yes.
Okay. My time is about to expire on the violent crime issue, so let me just make a statement and give you a chance to respond. On the positive front, General Mukasey, I have seen very good results in my area of Orlando, Florida, arising out of the ATF Violent Crime Impact Team, and I've seen very positive results as a result of 774 cops added to the streets of Central Florida through the COPS program. Can you give me your thoughts as we wrap up on the ATF Violent Crime Impact Teams and the COPS program?
The VSITs, the VSITs, the Violent Crime Impact Teams are part of, but not the entirety of, the anti-gang strategy that we've pursued. ATF has been superb in handling, I think, more gun cases than we've ever handled before. They are part, but not the entirety of the strategy. We try to do targeted grants using not only our own capabilities, but targeted grants at state and local entities that can work with us so as to maximize the resources that we can bring to bear.
In the COPS program, any thoughts?
COPS program is one of many programs that can be worthwhile, but was never meant to be perpetual. The point was to get police on the streets, have them effective, and then encourage state and local communities, as many of them have, to step forward and fund the increased forces that they have, which are effective.
Thank you. I wish I had more time to follow that last one up, but my time has expired. Thank you for being here, General Mukasey. Thank you, Mr. Chairman.
Linda Sanchez, Chair of Administrative Law and Commerce, and a member of Immigration Committee from California.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being here today.
Good morning.
Good morning. There are a number of different areas that of questioning that I have, and I'm going to try to get through them as quickly as I can. First off, in response to questioning before the Senate Judiciary Committee on July 9th about the allegations of selective prosecution of Alabama Governor Don Siegelman, you stated that there are, and I'm quoting you here, various avenues open for exploring those allegations, including having testimony on the subject. Given your assertion about the ability of Congress to investigate the Siegelman matter through testimony, I'm wondering, do you support KARL ROVE's decision to ignore a congressional subpoena on July 10th and refuse to testify about his role in the Siegelman matter and other matters regarding the politicization of the Justice Department?
As I understand it, Mr. Rove acted at the request of the President in response to an invocation of executive privilege. He has offered to meet with staff He has offered to discuss the matter
But
in
he's not
settings that
offered to
do
be
not.
under oath or to be subject to a transcript. And my understanding from prior court law, and I would expect an attorney general to know this as well, is that if the White House wishes to invoke a claim of executive privilege, the witness still has to present themselves before Congress and claim that privilege on a question-by-question basis.
With all due respect, I think that's a matter that is currently being litigated, on which I can't comment any further.
But prior case law has held that that is the case.
Don't know that. I know that that is a matter that is under active litigation and is, I believe, sub judice before a judge in the.
So you
in the
agree that
District of
KARL
Washington.
Rove can disregard a congressional subpoena?
What I'm
if
saying is
we
the
wish
question of whether an immediate advisor to the president has to appear at all when a proper claim has been made of executive privilege is a matter that I believe is actively before a district judge. And I shouldn't comment any further on that, and I won't.
I think if you brush up on your case law, you'll find that prior case law holds that not to be the case. And if we are talking about conversations that Mr. Rove had with others in the U.S. Attorney's Office in Alabama, for example, in the Siegelman matter, not conversations with the President himself, I have a hard time seeing exactly how the claim of executive privilege can be asserted if it wasn't advice that was given to the President or direct conversations with the President. But, you know, apparently we disagree on that matter. On the issue of non-prosecution and deferred prosecution agreements, out of the 40 known corporate monitors that have been appointed in deferred or non-prosecution agreements since 2000, at least 30 were government officials and 23 were former prosecutors.
Were government officials at the time they were appointed?
Previous government officials and 23 were former prosecutors. As I'm sure you're aware, New Jersey U.S. Attorney Chris Christie gave a multi-million-dollar no-bid contract, monitoring contract, to John Ashcroft, who was his former superior. I'm wondering if you believe that all qualified individuals should have the opportunity to serve as a corporate monitor in an open and competitive bidding process, or do you favor the selection of corporate monitors with no transparency and no accountability?
With all due respect, we enacted or put into place in March of 2008, after consultation with the United States attorneys, a set of guidelines relating to the appointment of corporate monitors that assures precisely the transparency that I think you advocated, and it goes from the start of the process to the conclusion of the process.
My understanding is those guidelines were issued on the eve before a hearing that we were holding on that very issue. I think that there was probably a strategic reason for trying to get them done before the hearing.
Oh, gosh, I was unaware of the hearing.
And furthermore, the guidelines have been criticized for lacking sufficient detail to really be of any significant use either to federal prosecutors or to the corporations that are entering into those agreements.
Why don't we await the experience that we have using the guidelines and find out whether they work?
Well, so far, we've not seen any instance of an open and fair and transparent process by which monitors are selected. It seems to be pretty much at the discretion of one person within the Department of Justice.
It is not. What happens is what's required under the guidelines with regard to when you get to the point of selection.
These are the new guidelines that just got released.
Is a panel of at least 3 people from whom a selection is made. That person has to be approved by the Deputy Attorney General, which assures uniformity. And the money that comes to fund somebody who serves in that position is paid not by the public, but by the corporation.
We understand, but there are still questions to whom that monitor owes a duty. Is it to the government? Is it to the people? Is it to the corporate monitor? That's not been spelled out in those guidelines unless something's been revised since March.
That monitor owes a duty to the duty that he undertakes to act in a fair, open, and transparent way. The fact is that ex-government people you mentioned put their reputations for fairness on the line every time they agree to do that.
And they also are paid oftentimes very lucratively. I would just say this because my time has expired. We would love to get additional information regarding the use of non-prosecution and deferred prosecution agreements. We'll look forward to that because so far we've not received all of the information that we've requested regarding those agreements.
Chair recognizes the distinguished gentleman from California, Darrell Issa, who serves on the Intellectual Property Committee, the Constitution Committee, and the Task Force on Antitrust.
Thank you, Mr. Chairman, and it's an honor to serve on those committees with you. General, a couple of things, and before I get back to the, if you will, this whole question of media, I'd like to just do a couple of questions on executive privilege. Earlier, Ms. Sanchez was asking about KARL ROVE's failure to appear based on an assertion by the President of executive privilege. What useful purpose would it serve if he came here when the questions are likely to be specifically related to items he's prohibited from telling us, other than to be a dog and pony show? Can you name a useful reason for us to have KARL ROVE here?
Congressman, I don't want to get in the middle of a controversy between and among congressmen as to what good or would or wouldn't be served. I know that the President's immediate advisors are subject to his claims of privilege, and notwithstanding their own desire or ability to discuss issues, if they're told they ought not to get into matters that relate to their conversations with him or his ability to gather information, they can't.
General, in your past experience, if you want to get to the truth, don't you usually try to get a written statement, sworn or unsworn, through request for production and so on? Isn't that a generally more effective way to do it? And isn't that what you would normally recommend for the efficiency of any body, that they try to get the answers in writing rather than schedule people if the questions are known and the answers are unknown?
I guess, again, I don't want to get in the middle of an intramural dispute here. There are various ways of gathering information. People use written interrogatories, they use live testimony, and I'm not demeaning the value of live testimony, but there are many ways, as you point out, to get.
Well, and General, I didn't plan on asking these questions, but since Ms. Sanchez did, I thought I'd try to make the record as complete as possible today because of your presence here. Mr. Chairman, I'd like to ask unanimous consent to enter in the record at this time a letter from Ranking Member Lamar Smith asking Mr. Luskin, who represents KARL ROVE, whether or not he would answer some very specific questions related to the prosecution of Governor Donald Sigelman, and then the accompanying answers in detail from Patton Boggs. Perhaps that would enlighten us at least until we can get further answers from some other source.
Without objection, so ordered.
Thank you. Having dispensed with at least questions and answers that do not assert executive privilege, General, you were unable to fully answer questions related to the current relationship of media leaks and how they affect national security earlier. I'd like to give you an opportunity to do it, but I'd like you to do it, if you would, also by commenting to, in your opinion, both before and after you were the AG, what the effects of organizations like the New York Times and so on leaking the most sensitive information have been as to the ability of us to conduct the war on terror and as to potential prosecution. So I want you to fully answer how you feel we would, because you're saying to us, show me a bill that I would sign. I'm saying to you, I fully agree that the leaks of classified information serving no purpose other than to take the most sequestered information, in some cases information that even some members of the Intelligence Committee haven't received, and divulge them, has hurt this country. But I'd like you to go from that and if you will, tell us what we need to do in order to stop that while respecting the legitimate use of the press.
I think, without going into detail or starting to criticize individual newspapers, I mean,
See, I'm not restrained from saying Eric Lichtblau and the other people who leak national secrets, but I understand that you wouldn't.
They ultimately get even by writing your obituary, so you have to be very careful with
I'm from a family of long livers.
with newspapers. But when when a statute and an obligation to disclose by the government that electronic eavesdropping is going on can be tripped even without an attempt to get at confidential information, such as where somebody who is under legitimate FISA surveillance or under Title III surveillance makes a call to a reporter, and that triggers an obligation to notify the reporter that he or she has been overheard on a wiretap, and then stops the government from using the fruits of that wiretap, that statute is seriously misconceived. I don't think that was the intention of the people who drafted the statute, but the law of unintended consequences operates just as much as the law of intended consequences, and sometimes in a lot more deadly fashion. And that's one of many fashions in which it could operate under this bill. In addition, there are numerous crimes that are not included within the list of crimes that are subject to the exception for being able to get at sources. For example, child abuse is not one of the crimes that are listed, so that somebody could do an interview with a child abuser and be able to claim privilege. And finally, there is no way to compel a reporter, even when a balance is struck as between the public interest in disclosure against the interest in keeping information private, which is it's apples and oranges put before somebody who has no other standard. There's no way ultimately to compel a reporter to disclose. A reporter is just as free as he or she is now to say, I'm not going to disclose, I'd rather take a contempt citation. There's no requirement, for example, that the information be put in the custody of the court and the matter then adjudicated with the information to be disclosed thereafter. The reporter retains the information. They're just as free as they are now not to disclose it. It also creates a possible lack of uniformity, given the fact that this is a jump ball for however hundreds of many judges there are. Whereas under current standards, uniformity is achieved by having these matters go up through the Justice Department and having them decided in a uniform way. As I said, it's a solution in search of a problem.
Thank you.
As currently drawn.
Thank you, and hopefully that gave you a little more time to speak on it. Thank you, Mr. Chairman.
Bill Delahunt, Chair of the Oversight Subcommittee of Foreign Affairs and a member of 3 subcommittees on Judiciary.
Thank you, Mr. Chairman.
Good afternoon, as it now is.
Good afternoon, General. Earlier, you discussed the issue of Guantanamo and used the word urgency to deal with the issues. I presume that sense of urgency also goes to the 45 detainees who are currently at Guantanamo, who have been cleared for release by the Department of Defense.
You're talking about the Uyghurs?
No, I'm talking about 45, including the Uyghurs, 45 detainees whom the Department of Defense has cleared for release, who are still being detained at Guantanamo.
And if there are, in fact, 45, and I take you at
well, let me suggest that that 45 list was given to Judge Hogan on this past Monday.
I have no doubt that it's accurate. The fact remains that we are not allowed to release people unless we can find countries that are willing to take them with the assurance that they will not be abused
and I understand.
when they get to those.
And I understand that.
And the State Department has been making heroic efforts at placing people, and it has been thus far fairly successful. The list has been sweated down from 775 to something in the neighborhood of 260. So
there's 270 plus detainees currently at Guantanamo.
Slightly fewer than that, but
okay.
In any event.
But we find ourselves in a position as a nation where we are detaining at least 45 individuals who have been cleared for release. You indicated that you would object to having those individuals or any individual repatriated to the United States?
Yes.
Okay. Let me again go to the issue.
Because the reasons why they have been cleared for release do not necessarily go to what havoc they could cause if they came here. They go to a whole lot of other things.
Other countries where they could create havoc?
No.
Right.
Other countries where they could not.
Where they could not create havoc.
Correct.
In other words, if an individual is inclined to havoc, that havoc will be limited by geographical boundaries.
It doesn't necessarily mean that those people were picked up by mistake or that they have ceased to be dangerous at all.
But
it simply
the
means
Department
that
of Defense is willing to release them if they're still dangerous.
The Department of Defense is willing to release them under controlled conditions if they can be put in places where they won't cause us additional harm. The Department of Defense has leaned over backwards, and in some cases we have all lived, and a couple of us have died, to regret it.
With all due respect, these 45, I dare say, if we should release them and they are still dangerous, we are doing a disservice to those of our allies that would be willing to accept them. But having said that, I want to get to the issue of assurances. And earlier, you and Congressman Watt had a colloquy about a case involving the director, the FBI director, in which you didn't have any particular knowledge. But just yesterday, we received a letter that I had authored along with the chair, Mr. Conyers, and Mr. Nadler regarding the case of Meher Arar. And you responded that you did not believe that it warranted the appointment of a special prosecutor.
I think you left out a phrase.
Well, give me the phrase I left out then.
At this time.
At this time. Well, thank you then. Because we have inspector generals that have stated that, in their opinion, it is of such, the assurances were of such a dubious nature that one of them, Mr. Irwin, interpreted to be that there could have been, and I'm not suggesting that's the case factually, but there could have been an intent, and these are his words, an intent to render to Syria rather than Canada because there was a knowledge or a likelihood of torture. If that doesn't trigger, in my judgment, the need for a special prosecutor, I can't imagine what would. But having said that and having looked at your letter, are you prepared, after your review, pursuant to our letter, that there was sufficient assurances from Syria that warranted the sending or the rendition of Mr. Arar to Syria as opposed to Canada?
I'm not certain I understand the question. I'm really not. You say, are you prepared, assuming that I believe that there were sufficient assurances? Am I prepared to do one?
Are you prepared to say that there were sufficient assurances on the part of individuals in the government that emanated from Syria to meet the standards of the Convention Against Torture and our own domestic legislation to render Mr. Arar to Syria rather than his stated preference, which was Canada?
So far as I'm aware, there was a classified briefing to the authors available to the authors of that letter as to what assurances were received.
Well, let me suggest
there can't be any change in the nature of what assurances were received. Things happen one way. Either assurances were received or not, and they were received in a particular way or not. But there was, I believe, a classified briefing to all three, or available to all three authors of that letter.
Well, it was available. I did not attend the classified briefing because I didn't want to be in a position to inadvertently discuss it in a public venue. But I presume that assurances that would be relied on by the United States government would be of such a nature that they would come from high-ranking officials in the United States government, particularly from a nation that's been described by the President as a practitioner of torture?
They were provided. I mean, I don't want to get into classified information either, and so I won't. Assurances were received by the United States government. That's all I'm prepared to say in this setting.
Okay, Mr. Attorney General, I would like to...
And I also find it, somewhat unlikely that somebody would hope to get anything out of anything that went on in Syria. So given the history that you pointed out, so the likelihoods kind of point the other way.
Well, let me express my gratitude for you making that statement. I'm still trying to figure out why Mr. Arab was sent to Syria.
He was a joint. I mean, he was a joint Canadian-Syrian national.
I understand.
Sending him to Canada could have posed a danger to this country. Sending him to Syria was safer, provided that we got the assurances, and it's my understanding that we did.
To be perfectly candid, that doesn't pass the laugh test.
About 4 or 5 minutes. The chair recognizes the distinguished gentleman from Indiana, Mike Pence, who serves on intellectual property and the Constitution subcommittees.
Thank you, Chairman, and Mr. Attorney General. Welcome to the Judiciary Committee.
Thank you.
Let me take the opportunity to thank you for your exceptional leadership on the recent bipartisan compromise on the Foreign Intelligence Surveillance Act.
Thank you.
You played an instrumental role in achieving a legislative accomplishment that I believe contributes greatly to our national security. As you might suspect, since we've debated it in one of the nation's largest newspapers, I want to focus my attention on an issue upon which we disagree. H.R. 2102, the Free Flow of Information Act. You've commented about it earlier, and I want to take the opportunity to raise some issues and pursue a line of questioning, but I do so with great respect. This legislation was introduced about 3 years ago by myself and my Democrat colleague, Congressman Rick Boucher. You've made your opposition very clear in this testimony today and in other public statements. Your written testimony today says that the bill, quote, would endanger national security by making it nearly impossible for us to investigate leaks of even the most sensitive national security information. Very aware of that. That kind of a strong pronouncement may be somewhat jarring to a committee that very strongly endorsed this legislation and to a Congress that voted 398 to 21 on October 16, 2007 to endorse this bill. I want to point out for the record that to Mr. Attorney General that this was supported by the Republican and the Democratic leadership. It was also supported by the ranking members of the Intelligence Committee, the Armed Services Committee, and the chairman of those committees. And I think it was supported precisely because we did endeavor to deal thoughtfully and carefully with precisely the issue that seems to be the focal point of your objection, namely concerns about national security. As you're aware, in the legislation, in the House version of the bill, we only provided a qualified privilege for journalists and made national security the leading reason for which the shield could be pierced. Our legislation permits compelled disclosure to prevent or identify the perpetrator of an act of terrorism against the United States, to prevent significant and specified harm to national security. You made reference to a child abuse exception not being included in the bill. I would think that would probably included by inference in the bodily harm exception in our bill, but I know the Senate includes child abuse in their legislation, and I'm open to it. It also allows compelled disclosure of sources in cases that involve the unauthorized disclosure of properly classified information that cause or will cause significant or articulable harm to national security. I think the inclusion of that very careful structure that does, at a point, call upon our judicial branch to exercise discretion, balancing our interest in national security with our interest in preserving the liberties upon which this nation was founded. It seems to be a focal point of your concern. But I want to begin by assuring you, General, that as the Congress tried to fulfill its role in addressing both our national security as well as preserving what we're trying to secure, that we did so in a way that made national security interests truly paramount. Which, of course, it comes in no surprise that Congress would act in this case. As you know much better than I, being an authority in the law, 1972, the Brandsburg case, Justice White actually virtually invited Congress to develop a federal media shield statute, saying that Congress had, quote, the freedom to determine whether a statutory newsman's privilege is necessary and desirable and to fashion standards and rules as narrow or as broad as deemed necessary. I guess my question would be, with a little latitude from the chairman to give you a chance to respond, is, you made the comment today that if 10 angels swearing on Bibles wouldn't change your mind.
No, that's not what I said.
Wonder, well, let me
they wouldn't change what's in the bill.
Wouldn't change what's in the bill. Well, let me say, if 10 angels swearing on Bibles wouldn't change your view of this bill, would 40 American journalists subpoenaed, questioned, or held in contempt do it? I mean, you said, Mr. General, if I may, you said this is a problem or a solution in search of a problem, but the Justice Department has argued that it's only approved 19 source-related subpoenas since 1991. However, the number does not include the number of subpoenas issued for non-source information. And also, since 2001, at least 19 additional journalists have been subpoenaed by both federal and special prosecutors, and you yourself know the Department of Justice guidelines do not apply to civil litigants or special prosecutors. I would say, with respect, this is not a solution in search of a problem. This is a constitutional, statutory response to a rising erosion of our First Amendment freedom of the press. And let me